Hello students and welcome to the lecture. So students, as we know that we have started the discussion over the fundamental rights, okay? And since last four lectures, basically we have been discussing upon the since last few lectures, basically we have been discussing upon the fundamental rights, okay? And as we know that we had started the discussion over the Article 19 of the Indian Constitution, okay? And basically we know that there are 6 types of freedoms which are promised under this particular article, like freedom of speech and expression, okay? Thereafter, freedom of assemble, thereafter, freedom of association, thereafter, freedom of movement, thereafter, freedom of residing, and then comes the freedom of profession. All right. So these are the 6 freedoms which promised under Article 19. Out of this, basically, we have done with the freedom of speech and expressions, we have done with the freedom of assemble, we have done with the freedom of movement, we have done with the freedom of residing, association also, and now we are left with is the freedom of profession. Okay, and basically in the previous lecture we had find out the freedom of movement and the freedom of residing. They both are overlapping and interconnected to each other. All right, that is what we had also discussed. Okay, so I hope that you have revised the previous lectures in the well enough manner before you have come for this lecture. As many times I have told you, that is for your own benefit if you are doing this on the regular basis. So now let's start with the article 19.6, okay, which is the right to profession. Okay, so if we talk about it, so remember, all citizens are given the right to practice any profession or to carry on any occupation, trade, or business. Okay, like we can say the role of government, or you can say the role of state, is restricted, or you can say prohibited in deciding the way in which the person will earn. All right, it means that if we talk about some countries, okay, which having the system, right, and the system is that the state government, okay, or the central government will decide at what professions, what trade, and what business the person could carry on. And the big example of this is the North Korea. Okay, in North Korea, basically the state will decide that what you will do in your future. All right, but we know that North Korea is the autocratic or dictatorship country, right? And India is not. So that's why in India there is a Article 19.6 which says that every individual living in this country having the right to choose his profession, to choose his occupation, or to start any trade or business. Okay, this right is very wide as it covers all means of earning one's livelihood. It means that whatever the person could do to earn his livelihood, to earn his money, to run his family and all, okay, he could do this. And all this protected under this particular right. The state can impose the reasonable restrictions on the exercise of this right in interest of the general public. Again, our golden rule of not absolute but qualified will be followed here. And basically here also there are some restrictions power granted to the government in name of the interest of general public. It means that if you carry out any profession, any occupation, trade or business which having the threat to the safety of general people, then basically the government could put the restrictions on you. Or you can say the government will stop you to pursue that particular trade, business, occupation or the profession. Okay. Further, the state is empowered to like prescribe the professional or technical qualification. That's the first thing. Prescribe the professional or the technical qualification necessary for practicing any profession or carry on any occupation, trade or business. Okay. If we talk about the big examples of it is, so suppose if you want to become a architecture. Okay. If you want to become an architecture, so you must have a degree of master's or bachelor's in architecture field. Okay. Until or unless you do not have that particular degree, you are not allowed to pursue that particular occupation. Similarly, if you want to become a doctor, okay, then you must require what? An MBBS degree. Okay. Without having the MBBS degree, you are not allowed to pursue that particular career. Okay. Similarly, if one more example we will see. So we know there is a chartered accountant, right? So for chartered accountant, you must require to have a recognition or must obtain the qualified certificate from Institute of Chartered Accountant in India, which is in short known as ICAF. Okay. So the first thing we could see here is that the government will not stop you to pursue any profession, carry out any occupation, trade or business, but the government may imply some professional or technical qualification as a necessary basis by obtaining which only you will be allowed to carry out that particular thing. Until or unless you do not obtain this kind of things, you will not be allowed to do the practice. Okay. Thereafter, carrying on by itself any trade, business, industry or service, whether to the exclusion, complete or partial of citizens of otherwise. Okay. Like it is the right provided to the state government, not state government. Okay. Provided to the state, or you can say in short the government. Okay. Like if they want to carry out any trade, business, industry or service, okay, then they could put the complete or partial restrictions on the individuals to enter in that particular business. For example, if we take about railways, if we talk about it, okay, so railways is the transportation business, right? Railways is the transportation business. So we know that railways completely is a government body and it's basically comes under the Ministry of Railways, right? no private player is allowed to run the train by their own. Okay. Similarly, if we talk about atomic energy, if we talk about defense, if we talk about some kind of other things, so basically these are the examples of complete or the partial exclusion of the citizens. Okay. Like you can say there are two main restrictions the state could impose on the individuals. The first could make certain qualifications or technical expertise as necessary. Okay. And second, could carry out certain things exclusively by its own and put restrictions on individuals or citizens partially or completely. Okay. So these are the things the state could do to put some restrictions in the Article 19(6). Thus, no objection can be made when the state carries on trade, business, industry, or service either as a monopoly like the railways or to the exclusion of citizen, all or some only, or in competition with any citizen. Okay. So basically, the state could carry out these things, and these are provided by the constitution. So that's why no objection could be taken on them. All right. The state is not required to justify its monopoly. It means that if someone challenges the state in the court that why they are not allowing the private individuals in the field of railways, why this and that, and why there is a monopoly of the state in this field. So this question will not be addressed by the courts. Why? Because there is a provision that no objection could be raised and state is not required to justify the monopoly. This right does not include the right to carry on profession, business, or trade or occupation that is immoral, trafficking in women or children, or dangerous, harmful drugs or explosive, etc. Like suppose you have opened a business of black sugar, for example, okay, and you say that basically it is my way of livelihood and it is a profession. But is this profession good for the general people, for the health and the safety of the general people? The answer is big no. That's why these kind of things, which is immoral and which is dangerous for the peace and you can say for the safety of the general public, then these professions will not be covered under the Article 19(6). It means you will not be allowed to carry out these professions in the name of your livelihood. Got it? Thereafter, the state can absolutely prohibit these or regulate them through licensing. All right. After this, after Article 19, we had finished it. Now we have the another article, which is Article 20. Okay, which is provides a protection in respect of conviction for offenses. Okay, like if we talk about accused. So, what is accused? So, accused in the normal sense is a person who has been declared under the charge for committing something which is against the civil laws or the criminal laws. So, that person is the accused. Okay, but accused do also have the rights for his opinion and for taking the protection. And this is basically provided under Article 20. So that's why it is now becomes a fundamental right, and thus the state and authorities could not deprive anyone to ensure his safety while getting the trial before any authority or before any court. Okay, it means that everyone will get a chance to defend himself and protect himself against the arbitrary nature, or you can say against the arbitrary actions during trials. Okay, so let's see. Article 20 grants the protection against the arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a corporation. Okay, like if we talk about it, so we had identified two main words here. The first is the arbitrary, uncontrollable, and thereafter the excessive. It means that if the person has committed only the 10% of crime, but he is getting punished for 110%, then it is wrong. Okay, and immoral also. Okay, and when we talk about the accused person, so basically we are not only covering the citizen, we are also covering the foreigner, and basically we are also covering the legal person like the companies or the corporations. All right, so all these comes under the definition of person. It contains the three provisions in direct action. It means that if we talk about the protection aspect of the conviction of offenses, so basically there are three main aspects which covered here. So this is important, please listen it very carefully. The first thing is the no ex post facto law. What does it mean? It means that no person shall be convicted of any offense except for a violation of a law in force at the time of the commission of the act. Which means that suppose if there are you, okay, and you are driving a car, for example, at 16 kilometers per hour. All right, but then you detained by the police for over speeding. So now you have been convicted under the charge of over speeding on the roads. Okay, but Article 20 is the first principle. No ex post facto law says that until or unless there is a law. Suppose if there is a law that you could only drive on 40 kilometers per hour, if you drive faster than it, then it will be a violence of the law. Until or unless that is notified by the authority or by the police, you will not get arrested for the driving at 60 kilometers. Because right now that particular law is not in the existence or not in the force. But if this law has been in the force and then you drive at 60 kilometers per hour, then what will happen? The police will get a legal right to detain you for over speeding. First thing clear? Like until or unless you breach some law or you committed the crime under the you can say particular law, and that particular law was in the force of that time when you can say committing the crime, so that will be considered under the first thing. Second thing is that suppose, for example, you were driving at 60 km per hour on 20th January. On which date you were driving? On 20th January. This law was passed on 22nd January. Okay, so that the police still will not detain you. Why? Because it says first thing is the breach of law that is in the force. It means first the law must be in the force. Okay. Second is at the time of breach, law should be there. Okay. It means that when you have been driving on the 20th January by 60 kilometers per hour, then this law must be in the force. But this law came into existence after the 2 days. It means that when you drove at 60 kilometers per hour, there was no law on that time. So that's why the police could not detain you. All right. So the first thing I hope has been clear to you right now. Thereafter, second thing is that subjected to a penalty greater than that prescribed by the law in force at the time of the commission of this act. What does it mean? It means that whatever magnitude of the punishment and the scale of the punishment has been granted in the law, that only could be applied to the person. For example, suppose you were driving at 60 kilometers per hour and the law prescribed the speed of 40 kilometers per hour. So the first thing is clear that you are violating the law. Okay. So you will be detained by the authorities or by the police. All right. What is the second thing? The second thing forms the part of penalty or punishment. Like what penalty or punishment would be given to you? That is the another question. Okay. So basically, suppose it was saying that if you have breached that particular law, so you are entitled to pay rupees 10,000 as a fine. So what is this? This is the prescribed limit of penalty. Okay. But when you got convicted, then you were asked to pay rupees 60,000. So is this amount, or you can say demanding penalty, is this demanding penalty is similar to the prescribed limit? No. Okay. So this will declared as an illegal or unconstitutional. Why? Because the constitution states person would only be subjected to the penalty or the punishment as prescribed. Okay. It should not be a greater than the prescribed limit by the law enforced at the time of commission of the act. So now I hope no ex post facto law should be clear to you. No person could be detained or convicted until or unless he or she violates some law which was enforced on that time when he committed some act. Second, he is not entitled to pay the penalty greater than the prescribed limit. Okay. Then comes the no double jeopardy. What is it? No person shall be prosecuted and punished for the same offense more than once. Okay. For example, suppose you have committed some XYZ crime on 21st March. Okay. For this, you got convicted and you had to pay rupees 10,000 as a fine. It means that you got punished. Okay. So once you get punished, the case will be closed down. Again, if on 26th March, the authorities will come to you and detain you and asking rupees 10,000 again for the crime that you had committed on 21st March, for which you get already punished. So that will be considered as an unconstitutional or illegal. Okay. Because no due party principle says, no double jeopardy principle says the person could be prosecuted and could be punished for the same offense only once. Okay, he could not be punished for the same offense on the repetition. All right, clear? Now let's move forward. Thereafter, another thing is the no self-incrimination. No person accused of any offense shall be compelled to be a witness against himself. What does it mean? In movies or in TV shows, you have seen that suppose this is the person. Okay, this is the police station. Suppose this person had committed some crime, then he visited the police station and he surrendered himself and he said that I have committed some particular crime like this and that. Please arrest me and all. Then what will happen? Within the 24 hours of detention, after his self-accusation, the police is required to present it before the court. Okay. Then what will happen? When the police will present that person in the court, the police will submit it the self-declaration statement on committing the crime, right? But what will happen? Do you think that court will see the statement and declare the person as a guilty and send him to the jail? No. The court will not accept self-incrimination as an evidence against the accused. The court will not accept the self-declaration as evidence against the accused. The court will not declare him as a guilty. Okay? And the court will ask the police to gather the enough evidences so that whatever the crime the person describing that he has committed, this could be proved. Okay? And this principle is basically derived from the no self-incrimination. It means that even if the person go to the police station and then go to the court and claims that he has committed something offensive, still the court will not admit or not accept that particular statement that the person has provided. Okay, and the court will ask the authorities to gather the enough evidences so that the crime could be implied on the person. So here we can say an ex post facto law is one that imposes the penalties retrospectively or retroactively, that is upon acts already done, or which increases the penalties for such acts. Okay, like you can say no ex post facto law will be applied only after the commitment of the crime and when the penalties will be applied or increases. Okay, the enactment of such a law is prohibited by the first provision of Article 20. Okay, it means that Article 20 basically prohibits any action of the state and authority to detain someone before committing the crime and then increasing the penalty on the person than the prescribed manner. However, this limitation is imposed only on the criminal laws, not on the civil laws or the tax laws. It means that when it's a matter of civil laws or tax laws, the authority is getting the liberty to increase the penalty amount than prescribed manner. And the best example of this, you can take it from the income tax department. Okay. In other words, a civil liability or a tax can be imposed retrospectively. Okay. So students, basically in this lecture, we have finished till here. In the next lecture, we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.